Katia Denise Henry James obtained a Bachelor of Arts degree, History and Economics with honors from the University of the West Indies in 1981, and obtained her LLB from the Norman Manley Law School in 1987 with honors, and is practicing law for 26 years. She joined the prestigious law firm Miles, Fletcher and Gordon in 1987 as an associate and worked with them for 6 years until 1993, doing work relating to probate and estate planning, commercial law, company law, and conveyancing. From 1993 to 1996, she worked with Sagicor Life Jamaica Limited, so she's no stranger to the insurance business, as a legal officer doing legal work related to probate and estate planning, land transfers, leases, commercial contracts, loan documentation, residential mortgages, claims, suites, and general advice on insurance company and commercial laws. She formed her own firm in 1996 and is a sole practitioner for 17 years, specializing in estate planning and probate. She's currently a part-time tutor at the Norman Manley Law School and has been tutoring final year law students in the law of succession for 20 years, and also marks exam papers for probate practice and procedure. Mrs. Henry James has written numerous articles on estate planning and conducted several seminars on the subject. Additionally, Jamaica's leading radio and television stations have sought her expertise in programs associated with estate planning. That's so true, including ourselves. We've sought her assistance in that area as well. She's a member of the Jamaica Bar Association for 26 years and was the company secretary of the University Hospital of the West Indies Private Wing Limited for 11 years. Her hobbies are reading, swimming, and cricket. Please join with me in welcoming Denise Henry James to the podium. And we want to do this a little differently today. We don't want a presentation, we want to just have her here to have a conversation with me. And of course, we would also ask for your involvement, because if you have questions, we're going to encourage you to ask those questions as well. Okay? So Denise, this matter of estate planning, we hear so much about it. Could you define the concept of estate planning for us?
Yeah. Well, good afternoon, everyone. It really is a pleasure to be here, but really what we want to do is to just share with you why we want you to plan your estate. And really there are just two main basic reasons for that. One, we want to try and minimize taxes that are going to become liable in your estate, and we want to try and keep any kind of complications out of your affairs which you may not even created willingly. So once you've borne that in mind, that you have to try and fix your affairs in such a way that you really try and reduce. Unfortunately, we can't totally avoid them, which is what everybody would like me to share. But what we really can do is try our best to get you to minimize taxes that are going to become due.
Okay. So what would some of the steps that you would take to accomplish this whole thing of estate planning? What would you be doing?
One of the things I want to encourage all of you this afternoon to be doing is look at your assets. Not just your assets, but also your liabilities. Because when you've looked at how you've owned your assets, it'll then make you realize that you have to pay these taxes when your estate is being administered. So what you have to be aware of is that there are a number of taxes, not the GCT, which we all know, not the income tax, which we're all paying, just for dying. And if I could share with you a formula for not doing that, I really wish it would have made things easier. Oh, yes. But we have to pay what we call death taxes, and that's just for dying. And that these taxes become payable by not you, but by your estate. And there are 4 main taxes that we have to pay. And I'm not going to go into too much detail, but just for you to realize that they consist of your transfer tax, your stamp duty, the attorney's fees, who's going to be handling the estate for you. And if you're familiar with doing your will, you know you would have had executors, or if you have no will, you have what we call administrators. Now, they are allowed a commission. So all of these taxes become liable in your estate when you do die.
Okay. So what would some of the steps be to ensure that you have planned?
Well, one of the first things I want you to do in trying to minimize the taxes is to try and make sure you have a will. A lot of persons feel that if they come to me as the attorney, they're going to die when they walk out the door just because they came to me to do their will. What you must realize is what the will really allows you to do is to take the time to identify who you want your beneficiaries to be. All of us here keep telling me we're not going to fight over the dead left. I'm here to tell you for 26 years, you're going to fight over the dead left. So we need to make sure that you took the time, you know the nature of your beneficiaries, so that you really provide for those who you want. Because unfortunately, if you don't do that and you die without a will, you would be horrified to know, because you've allowed legislation to come in to really determine who your beneficiaries are. And they're really not who your loved ones are. So the first step I want you all to do is to make sure you have a will. And I mean, ideally, I would like you to go to an attorney because you'll be guided not just in your will making, but get all the detailed advice. If you go to any of the stores or the stationery stores, you can get a time store will, as I still call it, because the only time store used to sell it long ago. And you only pay $100 for it. But you're not getting the sound advice that really comes with the importance of making your will. So the first step I want all of you to do is to make sure you do have your will.
Okay. So in terms of the taxes, you spoke about some of the taxes and that they're pretty high. Could you give us an idea as to just how high? I mean, what are we talking about?
The figure I want you to leave here this afternoon with remembering this. It's going to range between 15 to 17%. So when I ask you to look at your assets, if you look at your assets and you work out 15 to 17% of your assets, you're allowed to deduct certain liabilities. But unfortunately, it's very limited what we can deduct. So you take your liabilities from your assets now in 2013, and if you multiply that by the 15 to 17%, that's what your death tax exposure is looking like.
Oh boy.
And how they broke it down is you pay transfer tax for any assets that you own. You need to do what? Transfer it to your loved ones. But they chose your most expensive ones. Your real estate, everybody.
Yes.
Your shares in your company, whether your own private company you had or whether you've invested on the stock exchange. Any shares that you have, real estate that you have, and debentures, you have to pay transfer tax. And that now is currently at 1.5%. But you have to pay interest, and the interest is 6%. So before you can transfer any land to your loved ones, any shares or debentures, we have to pay this tax to the government before it can be transferred.
Oh boy. But you know, what are the consequences? Suppose you did not take heed and have a will. What would happen? What would some of the consequences be?
If you didn't have a will, then you have died what we call in law intestate. And what happens is we have a legislation that deals with that. And the Intestates Act then applies to your estate. Under that legislation, they have identified who your beneficiaries are. Now, it starts out great with persons that ideally you may have wanted to provide for, your surviving spouse. And we've actually opened up the legislation to not just persons who are legally married. We actually recognize now common law unions, because that's really the fabric of the Jamaican society. But they have a restriction. You have to be a single man living with a single woman, and I'll pick on the gentleman, for a 5-year period. Just before you die. And the act actually said only one such union qualifies. Although we have many baby mothers, as they like to call us now, only one of us will qualify as a surviving spouse.
Okay.
So there is a restriction, and luckily it's
mothers.
not the attorney who has to decide that one.
Yes. Yeah. So do you have any stories? I mean, I've heard several horror stories of what happened.
Because one of the horrors that I experienced it when I was at Mansfetch and Gordon, so it was very early in my career. And I remember the lady came in to me, and she came in and she says, you know, my husband has died, Mrs. James, and you know, you're going through a very traumatic time. Right. And then I said, well, did your husband have a will? And the answer I got was, no. So he had no will. I said, well, what are your assets? And she says, oh, just a home that we had, you know, we borrowed mortgage financing from NHT and all we have is our home. So I said, well, whose name is on the title? Hoping and praying that her name was on the title with him. She just says, yes, I think it's both of us. I said, well, do you know how you owned it? And you have 2 types of ownership, what we call joint tenants and tenants in common. So I was still praying for her now that it was joint tenants, because at least I could share with her that the property would be hers. Which she didn't come in with a copy of the title. When I got the title, and then she had her baby with her, and she says that the child was from the union, and it is a common law union. So I said, well, were you living together for the 5 years? Oh, yes, we were together for 9 years. At least I'm feeling good for her. When I got a copy of the title, however, on the title was not her name or her common law husband. It was in the name of the common law husband and his brother.
Oh, dear.
And it was the common law husband and his brother as joint tenants. Because what really happened is he couldn't qualify for the mortgage loan. He brought his brother in, asked him to join with him. He didn't understand that there was a difference in the type of ownership. His brother's name went on the title with him as joint tenants. So what was I telling the widow? The property automatically in law passed to the brother. At which point I know I was not on good legal grounds. So I invited the brother to come in and see me. And say, well, you know, your brother has died intestate. You know, he has his common law wife, and they have a child from the union. But your name is on the title as a joint tenant. So really and truly, the property will pass to you. But you really know he had hoped it would have passed on to his common law wife and the child. He says, Mrs. James, she has 30 days to get out.
Oh, no.
Yeah.
Yeah. Boy.
30 days, and he was in a good legal position
Position,
because he
right.
was telling me what really was the legal position, and that I was trying to play on the morals to whom. So it
Yes.
re-emphasizes again, you need to understand how you own your assets so that they pass to who you want it to go to. And more importantly, have a will, because if he had a will, he wouldn't have died intestate, and it would have passed to his surviving spouse, and she would have benefited at that point.
Even in the case of a will, though, doesn't it take some time to actually probate the will and
Well, the will takes, but your estates unfortunately are taking quite a while now to be administered. We used to take between 3 to 6 months to have your estate done.
Right.
It's unfortunately taking us about 8 to 12 months now.
Okay.
So whether you die with a will, it is taking that. If you have no will, which is what the scenario I was sharing with you,
Yes.
it's taking us 2 to 4 years.
Years.
So none of your
Okay.
loved ones will get any of your assets until we have had the estate administered, and it's taken that length of time before we can transfer it. But even if you get over the hurdle of the time frame, the taxes have to be paid.
Okay.
And that's where we come into this problem now, where we're going to pay it from, and they're to come from your assets.
Oh dear.
And that is where we really have a bottleneck in trying to get the
Absolutely.
estates done.
And if you don't have the funds available, it would be the property might
That's
have to be
right.
sold to
That's
cover the
right.
taxes.
That's right. That's
Oh
right.
boy, that could be a very difficult situation. So, but you know, we have been involved as individuals. We have very many methods of saving. We have insurance policies, we have bank accounts, savings accounts, we have, in addition to the real estate.
Right.
What would you say are some of the best practices in relation to these types of products, like a bank account? What should you do when you have a bank account just
All
to
right, what I
plan your
want
estate
everybody to
properly?
leave here with is remembering what? That 15 to 17%. So I want you to look at your assets, and you have mentioned some of them. But there are simple things you can do. For instance, in your bank accounts, do not have it in your name alone. Because if you're a sole owner, it's waiting for your estate to be done, the taxes to be paid, and then have it transferred to your loved ones.
Yes.
So I want you to try and have the majority of your assets jointly owned. So although I gave you the scenario of the real estate, I want you to do the same thing for your bank accounts. Now don't leave here saying what Mrs. James said, put on somebody's name on the bank account. You have to make that decision, because whoever's name you put on that bank account, guess what? The money is theirs when you die. So we can't force them to put it back into the estate to help us with these death taxes we're talking about.
Right.
So you really want it to go to who you want it to pass to, but what you're creating is liquid cash to help in the estate.
Absolutely.
So I want joint bank accounts. And again, put them on, but don't give them any signing authority. So you're really putting them on for estate planning purposes. Same concept I want you to do for your real estate. The more real estate you own as joint tenants, it's the less taxes we're going to pay. Because remember that 15 to 17%, it will come down because it's not in your estate when you die. It passed to, like that example I shared with you, to the surviving joint tenant.
Absolutely.
And I want you to do the same thing for your shares. Don't have it in your name alone. I want it to be jointly owned with one person, two persons. The more persons that are on it is the less taxes that are going to be paid when you do die. What unfortunately is giving me the greatest challenge now, and you're probably not thinking of it, is your motor car. Think of it. You've left back your motor vehicle, but when you die, we can't transfer it because it's in your estate, and it's taking a year or 2 to 4 years to get it transferred. So what we want you to do is have what? Somebody's name on the title for your motor vehicle. We can get your beneficiaries to have your car driven, we can have it insured, and we can have it licensed, but what we can't do is change out the ownership. But I need you to really look seriously at it, because what is now coming in is one of the death taxes, which is the stamp duty. We're going to be paying it based on the value of your motor vehicle, together with the value of your land and your shares. So look at your assets. Try to not end up with it being owned solely by you, because the more that you own jointly is the less taxes you're going to be paying when your estate is being done.
You know, I have to mention insurance policies.
yes.
So we're the insurance company.
The beauty of your insurance policies, remember we heard me talking about the 15 to 17%? You do not pay it on your life insurance policy. You had an option when you took out your life insurance policy. And we had what was called the Married Women's Property Act. So it was limiting to husband and wife. But if you named a beneficiary on your policy, then whoever you named on your policy, they would get the proceeds, and it is not in your estate. So you're not paying any of that, 15 to 17% at all. And you've named the person, so you've already took time to say who you want the proceeds of the policy to go to. So it is a very fantastic asset. It is an asset that you don't pay the death taxes on, and you can determine who you give it to. Now, if you didn't name anybody, then you would have been told, you could have put on the word called estate. And literally what it is saying is your estate must be done, and then whatever your will said, That's who we give it to. If you've died intestate, it's who the law says we're going to give it to. But the minute you put estate, you have locked it into now your estate to attract not the transfer tax, but you will get the commission we pay to your personal representatives.
Sure.
The attorneys will get their fees on it, and you're going to pay stamp duty on it. So what my advice tonight is, have your life insurance policy, but have what? Named beneficiaries. And we have amended the Insurance Act, which has allowed you to name anybody on your policy, not just husband and wife and children, so you can put anybody on the policy.
Absolutely. Folks, you heard it here. Insurance policies are a great way to plan your estates. So I'd like to, offer the opportunity to our people here tonight. If there's anyone who has a question, is there anyone with a question? A burning issue that they'd love to discuss here tonight? Oh, I see a hand over there. Yes.
Okay. They may want to keep you limited to the spouse or the children. But at least, you can change it from estate and put on a name beneficiary, but you may be restricted in only putting on spouse or children. But approach the insurance company and ask them if they will allow you to make the change, because they want to not have it in estate so that you're not paying any of the taxes at all. But it really is a business decision that they will make.
And one other question, does your will have to go on a will form?
No. Under our Wills Act, which is what is governing it, it only has to be in writing. So it can't be on your computer, as I've seen happen, and you never printed it and you never signed it. Because for it to be valid, it has to be signed by you, the testator, in the presence of two persons who ideally are not beneficiaries under your will for it to be valid. So it could be on a diary. I have probated wills where you're at your office, you took up your stationery, which was used, you flipped it over, and you wrote it on the back. It just has to be in written form. It doesn't even have to be in your handwriting. I can write it for you. Somebody can write it for you, but you must sign it, and in the presence of two witnesses, because we then may have to call upon them to speak to the veracity that you did sign the will and intended it to be your last will and testament.
Is there anyone else with a question? Yes.
The situation that you spoke of, where the gentleman's property belongs to the brother, and it was in joint tenancy, would he able to pass any of that portion on to his wife if he had a will?
No, because remember I even started off by telling you with will making you could do it on your own, but the lawyer would have advised them that because of the type of ownership, he did not own it to give it away, because he owned it as a joint tenancy. But what we would have encouraged him to do was change out the ownership from joint tenants to tenants in common, so at least he ended up with a 1/2 share, have his will, and in his will he would have left his 1/2 to her. Because as it was structured, there was no way to pass it to his wife at all.
Thank you.
Is there anyone else? That's it? Oh, yes.
What of trustees? Say you have children. I've heard it said that the best arrangement is to leave, say, 50% in your husband's name, 50% in the name of the children, and then a trustee. Is that a good way to go?
Well, the whole reason why you want a trustee is if you have minors. So the minute you have minors, and that just means in law that your children are under 18, then you really want to appoint somebody to be trustee for them, because you don't want an 18-year-old to be inheriting all the assets because they're going to squander it. So you want to have what we call trustees and appointed to act on behalf of the minor. But you need to do that again. You can do it in your will as a testamentary appointment, where you're appointing your trustees in your will. Or on your life insurance policy, you say John Brown, Mary Jane as trustees on trust for the minor that is involved. But what it gives you is greater flexibility in your will, for instance, that is not just limited to children who are under 18. Think of your scenario. You may have adults, 30, 40, but they may be alcoholics. They may be drug addicts. They may be spendthrift, meaning if they got the money tomorrow, they would spend it and squander the asset. So in your will, even though they're over 18, you may still want to do what? Appoint trustees to take control of the asset and then give it to them when the will says. I mean, I'm doing wills where they're not getting it till they're all 50, so that you have trustees investing it better and have it there to maintain them until they get it outright as the will dictates. But you're really appointed under your testamentary document.
Thank you. And how does the taxation scenario work out in the instances of trustees?
Right. If you have trustees, you mean under the will? Right. If you have trustees being appointed under the will, then the assets will be transferred to the trustee. So in that we're going to pay that 15 to 17% death taxes that we alluded to. You pay that, and then you put the trustee's name on your real estate. the trustee's name goes on the bank account, and that they're going to keep it there and administer the assets until the person becomes of age. So there's no more tax once you've got them on. It's only the death tax of the 15 to 17% that you're paying up front.
Going back to the earlier scenario of the several baby mothers,
Right.
how legally do you decide who is at the front of the queue?
All right, well, luckily, Cliff, it's not the attorneys who determine it. Once you've died and you've left a common law spouse, meaning you've satisfied under the statute, then what happens is the common law spouse is supposed to produce a document which shows that they're the common law spouse, both for the husband or the wife. Now, if you're legally married, you're going to present the marriage certificate, and we present a certified copy of that which verifies it. For the common law unions, however, there is what they have to do is go and get a declaration from the Supreme Court declaring them to be the common law spouse. So the applicant declares that I'm a single woman, he was a single man, we were living together for the statutory 5-year period. They have to get supporting affidavit evidence from some person who is familiar that they were living together as husband and wife for that 5-year period. The judge in chambers then makes the determination. And when they've made the determination and you get this written declaration, then they now become a common law spouse. And under the Intestates Act now, they really get the bulk of their estate. Because under the Intestates Act, the common law spouse gets all the personal chattels. And by chattels, they define it as your household contents, your jewelry, your motor vehicle, the money in the bank account. They get that outright. What's left now, they share it with children. So they really benefit under our Intestates Act, but they have to get the declaration. And if they don't, then we have said the person has died without a surviving spouse, and we look to the next category of beneficiary. After spouse, you then have children. And we don't discriminate anymore. So we no longer discriminate for children born in wedlock and outside of wedlock. But again, the children have to show they are the children of the father that has died. So what they now have to produce is a birth certificate. And we're praying and hoping that the father's name is on it. If it's not, we have to get a declaration of paternity. But once they've overcome that hurdle, then the children share outright. If there's no spouse and there's no children, then we go to the next category, which is parents. And parents take absolutely. If I have none of the 1 to 3, the next category is grandparents. After grandparents is brothers and sisters. After brothers and sisters is uncles and aunts. After uncles and aunts is what we call the crown, which is really the government of Jamaica. You didn't hear me say niece. You didn't hear me say nephew. You didn't hear me say cousin. You didn't hear me say grandchildren. They don't get at all if you've died without a will. That's just how terrible it is, because if you have your will and you wanted to leave everything to your niece, that's the only way you can do it. But the common law spouse has to go and incur the cost of getting a declaration, and they have to satisfy the judge that they are, because when Peter Tosh died, 3 women came forward, all for the same 5-year period. So the court had to make a determination, because remember the act said only one such union qualifies. So they had to determine which out of the 3 satisfy the requirement under the statute. Again, just on the affidavit evidence that was before them, who you really spent more time with as husband and wife for the 5-year period. Yeah. Yeah.
Just clarify, what if in the case of you were going through a divorce
Right.
at the time when you died and you had been living with somebody for 5 years as a spouse and have a family with that person, but at the time of your death, the divorce is not final?
Right. Right, because again, under the, oh, sure, go ahead.
Okay, I was just asking in the case of if the persons are getting a divorce, and when the person dies, the divorce is not final, but they had been living with somebody and started a family, and they're assuming that they're having a common law relationship.
Right.
So
right.
5 years, have family, have children, but the divorce not final at the time of death. But,
Right. Well, again, under the same Intestates Act as I'm alluding to, you have to be a single man or a single woman living with, the vice versa, a single man with a single woman. So by single, it meant you have to be divorced. So even though they had started proceedings, as you've alluded to, you have to have had the absolute, the decree absolute. If that has not been issued, you're still what? Married to the estranged spouse that you have, even though you have moved on and you have a common law relationship going on, that person is going to be treated as the surviving spouse, not the one you were living with for the 5 years just before you died. So you have to be widowed, or you have to be a divorcee, meaning the absolute had to have come through for you to qualify as a single man living with a single woman. And the same thing for the woman.
Perhaps you could clarify for me. I wondered about that. You remember that famous story of Bob Marley and the several children outside of wedlock. How does that work in the event that you are married and you have children within the marriage, but there are several children outside of the marriage?
But
How
remember,
does that
I had
work?
mentioned that under the Intestates Act, we don't discriminate anymore.
Okay.
So once you have children, whether legitimate or illegitimate,
Right.
under our Status of Children Act, we are treating all children equally.
And even if you have a will that states
And even no,
specifically?
well, if you've died with a will,
Yes.
we're going to give your gifts to who you've named in the will.
Okay.
They're going to get that outright. So the outside children, if you didn't provide for them in the will, there's nothing that they can get there. However, all is not lost,
Yes.
because we realize that this is what is happening. And we passed legislation, which is the Inheritance Provision for Family and Dependents Act, which says if you qualified under that act, which now would be those children,
Yes.
but they had to have been maintained by their parents. And if they were being maintained by daddy or mommy, then they can bring a claim that the maintenance will continue, even though mommy and daddy have died. So they don't benefit under the will, but they can bring a claim to become a dependent and to get maintenance under that legislation.
And of course, it's a burden of proof.
And right.
He's actually the father.
Right, right.
Gentleman over there, you want to ask a question?
Oh,
Hi. If a will has been made in Canada or the United States, and your estate that is now in Jamaica is not included in that will, is it applicable?
all right, well, let's just separate the two. If you had it in Canada, which is a Commonwealth country, once you had the will in our jurisdiction, are you giving me those facts? We have a will in our jurisdiction? If the person has a will in Jamaica, and that will is going to be dealing with the assets in Jamaica, we then realize that the person has assets in Canada, just using the example you're giving us. We can take that will and do what we call resealing. So we take the grant that we got out of our local courts, send it over to Canada now, and have it resealed in Canada, for instance, and all Canada is going to be doing is what? Focusing on just the assets now in Canada, and they're going to use this reseal grant in Canada to deal with the assets there.
If it's the other way around.
Versus, you can get the grant in Canada. When you've gotten the grant in Canada or any Commonwealth countries, I could pick New Zealand, Africa, and so on, or in England, we then reseal it in the Jamaican jurisdiction, and we're only dealing with whatever assets you have in Jamaica now, so that we can transfer your assets in Jamaica. However, now, when we want to transfer your assets in Jamaica, where are we at? 15 to 17% of the value of the assets in Jamaica, not what is going to be situated in Canada. America, their laws are totally different. So you have to get another grant all over to deal with your assets in America. But for the Commonwealth countries, we shorten the process because we're Commonwealth jurisdictions, and we're taking you to the stage where we just tell you to get a grant from the one that was already issued from a court in a Commonwealth country.
Could the will supersede the case where the divorce is not final? If you want to exclude the spouse, if that's your wish?
No, well, the will is going to speak. So once the will is valid, signed by you in the presence of two persons, we must honor whatever the will has said. And we have to do in law what we call probating the will and give the assets to what the will had said. So it can't supersede that. Okay? The will is what is going to speak and give the asset that way. Okay?
I just want to follow up on that question. So are you saying that it's possible for, and I put it the way I'd like to put it, a wife to totally exclude her husband from her will and leave her assets to some other person?
You see how he's
Listen, well, wives.
All right, listen. The will just has to be signed by you, as the Wills Act is saying, in the presence of two persons, and it's valid. And you have in law what we call testamentary freedom. And having said that, that meant you have the freedom to disown particular categories of beneficiaries, and if you wanted to give it to the cats of Jamaica or to whatever, you can. But you have that freedom. But it doesn't sit right with us, that you can disinherit your loved ones or your children or your parents. Remember, those were the three top categories we had. So because of that, that was why the Inheritance Act came in. Because they tell you you have the freedom to have your will, and I want you to have your will. But you really can't disown those persons, because if you are maintaining them, and that's what's critical, and they were dependent on you while you were alive, meaning you were paying the mortgage for the spouse, or you're paying the rent, or you're paying the grocery bill, or you're paying for your children's education, they're dependent on you. So though you left nothing for them in the will, under the Inheritance Provision for Family and Dependents Act now, they're coming after you. And they're going to have to verify, because they have to bring the claim. So again, it's their responsibility to come and show mommy and daddy was paying my school fees, here's the bill. Mommy and daddy was paying for the mortgage or the rent, whatever. And then a court will give an order to maintain that, lump sum, periodic, whatever. So you still have the estate liable to do what? Pay that. You have to bring that application before we've distributed the estate, which is what you're hoping. So that before we have done that, you bring the claim that you will then benefit from a court order to make provision for you. But you must be maintaining those persons. They can't use Inheritance Act now to say, well, oh, let me now run to university and let daddy and mommy pay for the fees. They had to have been in university or higher education or vocational training, and you want the court to give an order that the estate take out some of the money to pay for that.
Okay.
And behind you have to spin now. Yes, sorry, ladies.
Just a hold, we're bringing the mic for you. We're bringing the mic.
I have many questions. I'm also in real estate, but most importantly, coming out of this, I wanted to find out if when you make a will and you have the two witnesses, if at the time you die, those witnesses are also not around, how do you treat that? That's one. And the second question is, in the case of the trustee, who protects the interest of the minor? If it is that the trustee spends the minor's
benefits. All right, so let me deal with the first one. Come again. The two witnesses, right. All right, the will has to be signed by the testator. Forgive me for spinning, right, but how it's set up. It has to be just witnessed by two persons. Now, we have had a lot of problems where we either can't read the handwriting, so we don't know who the witnesses are, or even if we have managed to read the handwriting, we can't find them, or more importantly, what you're saying, they may have died as well. So they're not there to speak to the veracity of the will. So we did make some changes to what we call our Civil Procedure Code, where we have said once the will has a clause on it which says, signed by the testator, and I'm just breaking it down, in the presence of two persons who are present at the same time, they no longer need to have the witnesses come and give such evidence. So we don't need to be doing what? Searching for the witnesses anymore, or hoping and praying that the witnesses are alive when the person's estate is being done. But even if we needed it, because if the person's signature is shaking, which is usually the common one, because with age the signature doesn't look the same, the registrar can still ask the attorney to verify that the will was properly executed under the Wills Act. So we have affidavit evidence where I will get evidence from somebody who knows the signature of the two witnesses. So suppose it's done in a law firm. A secretary may be familiar with the signature of the testator, number one. So they do what we call an affidavit of, handwriting of the testator. Then we have to find two persons who know what? The witness's signature, and they do an affidavit saying they are familiar with the signature on the will. They're saying that is their signature, and the fact that we're seeing it, the court will then allow us to go ahead and probate the will. But they've said that once it just says signed by the testator in the presence of two witnesses, we don't have to call on anybody to verify anymore. So they literally waive that requirement.
And that will cannot be valued unless two people sign it.
It has to be two.
Compulsory.
Has to be two. It's not valid if you have one. And you know what some persons do? They give me one, and the one person is a justice of the peace. So they think because it's a justice of the peace, they have satisfied it. Our Wills Act says it has to be two persons. One doesn't qualify. Yeah, well, if not, the will is not valid. And if the will is not valid, you've died intestate, and we're back to that unfortunate scenario. Now, with the trustees, you want to appoint the trustees, and you can do it under your will, as I mentioned to you earlier. The assets, as you heard me tell you, are going to be transferred to the trustees. So you realize we're putting a lot of faith in the trustees, because their name is going on the title, their name is going on the bank account, you're paying them over from the insurance proceeds. So we can't stop them from investing in OLINT or Cash Plus. Right, Cliff? You can't stop them from doing it. But you can sue them in their capacity as trustees because it is not their money. They're holding it as trustees on trust. So the beneficiary who should have gotten it or you squandered it and made bad decisions, we can sue them. And a court can say that what? They're liable to pay back, what should have been a benefit towards the beneficiaries. Yeah.
Oh, sorry, one more question back there. Over there, that one.
Oh, they're not easy enough.
Did you say that the will, the two persons that have to bear witness, it has to be done at the same time?
Yes.
Okay.
Yeah. Same time. Because that's what they're saying too. They're saying they were together. Like, no, if you're signing your will, Lana and myself have to be here. We watch you sign your will. So we see you put your signature on your will. And then we take the document and put our signature on. Lana then puts her signature on. And what we're saying is, we saw you put it on in the presence of the two of us.
Does it have to be in the same pen? Someone just asked the question.
Yes. Yes.
Same pen.
Because when you start to look at it, remember that time store will, nobody's guiding you, you're just going ahead. It has to be in the same ink because we're trying to minimize any doubt that something is not happening all at the same time. So if the ink is running out and the inks are different or the handwriting is looking different, the will may still be valid because guess what? The testator signed in the presence of two persons. But we have to do an affidavit for the court where we say just that. The ink ran out, this one took up this ink, this one did that, this one wrote the first clause, somebody else wrote the second clause. So we're satisfying that the document is complete when what? The testator is signing it so that it really reflects his wishes as his last will and testament.
We have a problem. What if the executor dies?
All right. All right. All right, so under your will now, just like I kept telling it needs to be signed by the testator in the presence of two persons, we want you to appoint executors. You can appoint a minimum of 1, a maximum of 4. I want 2 because the odds are better when you had 2. So even if one died before you, remember I told you that if they came to me, the attorney, they think they're going to die. When they've done the will and they know one of their executors has died, they're still not changing the will. So odds are, by the time the estate is being done, I still have an executor being appointed who has what? Predeceased, the testator. But if they have died, I can use the other executor, and I just refer to the fact that the other one has died and exhibit the death certificate. If the two of them have died, I still have a what? A valid will, because you're all still with me, I have a valid will. But the two executors having died, I have no living executor. So you know what happens to that person's estate? I'm not applying for probate now. I'm applying for a grant of administration with the will annexed, which means I honor what the will says, but I need an individual to be appointed. And I have to go through the Administrator General's office, and I'm back to that Intestates Act as to who can now apply for the grant. It takes 2 to 4 years now.
Well, I was just thinking about what if there's not sufficient fund to take care of all those taxes and the lawyers' fees and the
that 15 to
executive
17%,
fees.
that's right. And in the majority of the estates, because nobody planned for it, nobody had the insurance policy to help us, what happens is we still owe the tax.
No, what happened is like the bank account is in the the person's name.
So it has gone to them?
The person died, they just went to...
Yes, because it's their money. But we still have the other assets. So whatever asset we have in the estate, what we have to do now is sell your assets to come up with the 15 to 17% to pay it to the government.
And to distribute according to the will.
That's right. That's right. So what is happening is, I have seen many a will where you say to me, the family home is never to be sold. The family home is to be left to all my loved ones. But nobody planned for it. So nobody prepared for the 15 to 17%.
And the maintenance.
And that's right. So I now have to turn around and sell the real estate. And I'm not selling it when the market is right. I have to sell it when? No. So I'm not going to get the best price for it and use that money to pay off the taxes that is owed to the attorneys, the government, and so on.
But when you're dead,
You're in heaven. And
You're happy, you don't need to worry about it.
When you're dead, you're dead.
That's right.
Nobody
And you
can
are the
administer
happy
it from the
one.
grave.
And I'm here to tell you, all your loved ones are going to fight over the asset before I even get your estate to be administered, you know.
Yes.
They're moving with your household contents.
And number one. Number two. No, don't a will is private, separate and apart?
Yes, it is. A will is
Thank you.
private, but as long as you keep it private. When you have prepared your will, I don't want your loved ones to know what you've put in the will. Because they may not like what you put in the will, and they will go and destroy it, find it, tear it up, and hide it. So that you need to make sure that you keep it private. And by that I mean, the safer you keep the will, the better for the estate. Meaning, not at home in your top drawer, not underneath the mattress. I want it in a safe to deposit box, or a pan that you have at home that is locked, and you limit who has access to it. Because you really want to keep it private. Because what happens is, even though you've done your will now, and you've gone and told your loved one, oh, I was leaving this real estate to you, you can change it tomorrow. Yes. That's right. So you need to keep it private, because it is ambulatory, so it only speaks from the day that you do die. So you need to keep it private. I don't even want the copies. I only want the attorney to keep a copy. And you to keep it safe in your safe to deposit box, because if we can't find it, that meant you either intended to revoke it, and not that you had it at home and somebody destroyed it so that we couldn't find it. The attorney will have a copy of the executed will. We can probate a copy of your executed will, even if we can't find the original. Okay?
We're having a wonderful conversation. This is so interesting, isn't it? But I think we need to move on to some other aspects of the program tonight. So I just want to thank you, Denise. That was
My
so
pleasure.
illuminating.
My pleasure.
We know what we need to do. Thank you so much.